Okay, so our recording has started and hopefully it will work fine, just like last time and every time.
Okay. Let's hope.
Okay, Sandeep ji, so I have given the mic to you, so I mute myself and you can go ahead and speak about your case as well as WP and PAL, etc.
Sure. Thank you, Vivekji, for the opportunity. This is a petition which concerns to almost everybody who is facing false matrimonial matters, criminal cases specifically, and even within the criminal cases, Section 3 of Dowry Prohibition Act 1961. We all know what does the Section 3 Dowry Prohibition Act 1961 says. It criminalizes 4 acts of people. One is to give dowry, second one is to take dowry, third and fourth are abetting to give and abetting to take. So someone who encourages, motivates it, or forces to give or take dowry is also criminalized under Section 3 of Dowry Prohibition Act.
Uh,
Now,
just one interruption, Sandeep ji. I think I'm hearing your audio to be a little bit low. So, uh,
okay,
and there
is
is
it
a
any
little bit
better
of,
now?
uh,
Is it any better now?
uh,
Okay, I think the
yeah,
mic problem. Okay, is it
yeah.
any
Maybe
better
you
now?
can be a little bit closer to the mic.
Yeah.
Yeah. Okay, great.
Can you
So
hear me now
proceed.
clearly?
Yeah, I'm hearing a little bit of breakage. In case other people are facing the same issue, just confirm.
Mhm.
Is the voice clear to everyone? Sandeep ji's
Is
voice?
my voice clear? Audio clear, please?
Yeah,
It
it's
is clear.
clear.
Thumbs up,
Yeah,
if
it's
it's
clear.
clear. Okay. Okay, fine. So maybe it's my problem only. If everyone can listen fine, then there should not be a problem in recording. So okay, I think one suggestion is Sandeep ji, you make speak a little slowly
Okay,
because this is a legal topic which people may want to assimilate and while you're speaking in real time.
understood.
So that's one
Understood.
suggestion.
I'll go slow. I'll go slow.
Oh, okay. Yeah, proceed. Yeah.
All right, thank you. So, as I was speaking, our problem with false matrimonial cases, especially on criminal side, are curtailed around 498A IPC, Section 3 and 4 of Dowry Prohibition Act. Now, we don't have much problem with the 498A IPC. We can handle the cruelty aspect and win the cases, not a problem. Same is the case with Section 4 of Dowry Prohibition Act also, which criminalizes demand of dowry. Whoever demands dowry is punished with a punishment of 6 months to 2 years. Now the problem is Section 3 of Dowry Prohibition Act. It is a very peculiar section because that criminalizes more than one act and at least 2 people are necessary to commit that crime. It's a transaction basically. So for the Section 3 offense to be in the FIR, people have to identify who gave dowry and who took dowry. Without these 2 people, the offense.
Okay. It looks like Sandeep ji has been disconnected. Let me see. Yeah, I think he's been disconnected. Let's wait for some time. So, okay, he has joined again. Okay. Yeah, go ahead, Sandeep ji. I think you were disconnected.
Yeah, sorry for the disconnect. It was network issue. Yeah, like I was saying, Section 3 is a very peculiar offense. It requires at least 2 people to commit that offense, especially the giving and taking of dowry. When this idea struck me, when I was part of many men's rights groups, I have discussed this with many leaders as well as members. So all of them have clearly identified this as an anomaly. Only one party to the transaction is being punished in the FIR, or at least marked as an accused in the FIR, but the other party who is alleged to have given dowry, they are considered to be innocent victims. They are not considered as accused persons who have committed the offense of giving dowry, but they are innocent people who had to give dowry because of pressure from the other party, the groom party. But that is not so. That might be the ground reality, but the law doesn't cut scenario. Whoever gives or takes, that is how the section starts. So considering this aspect, I have come up with this writ petition wherein I have raised multiple grounds, not just one, multiple grounds and lot of facts all the way from parliamentary debates to NCW reports that were sent to Law Ministry. All those things are accumulated in this petition, and this was filed in September 2021 before the Honorable AP High Court. Currently, the status of the writ petition is being discussed in the open court, which is a very fairly new thing to me. I did not expect that the honorable courts would open up the question of law to the entire advocate community. Having said that, till date, the respondents in this case have not filed a counter. The respondents are: number one respondent, Union of India, Law Department. Second respondent is State of AP, again, Home and Law Department. Third respondent is Director General of Police, Andhra Pradesh. And the fourth respondent is the concerned police station's SHO. So I'm asking all these respondents, under what rule or authority or law you are exempting one party to a crime and only accusing one second party to the crime? None of them have responded to my representations. When I sent a representation to them directly, asking them what is the basis for your action in prosecuting only alleged dowry taker but exempting dowry giver. Even though from our men's right conversations, we know that there is a section under section 7.3, but none of them even raised that excuse before me. They did not even consider appropriate, or at least courtesy's sake, to respond to my representations. After my representations did not elicit any response, nobody replied to my representations, that is when I filed the writ petition, taking all the representations that I filed to these four respondents. Till date, no counter is filed. My firm opinion is that the respondents cannot take a position. They are in a situation, if they say yes, there is a difficulty. If they say no, there is another difficulty before the respondents. So my questions, my prayers before this honorable court is very simplistic. I'll just go to the prayers portion of this petition. Vivekji, can a little up towards the prayer section? A little up. Yeah, this portion. Now, look at the prayers that I am asking. Many from our men's rights groups, many people have raised this topic of Section 3 issue before the Honorable High Courts. Many have done that, but almost everybody failed. The reason is we are asking the wrong questions till date. We are asking, why am I being punished alone? Why not the other person? Quash my case. Because if the transaction is true, other person should also be in the case. Why is the magistrate not including the dowry giver under 173(8) CRPC? So there are a lot of technical grounds many people have taken. I went through all of them, and they have done a commendable job in bringing light onto this aspect, Section 3 aspect. But then what I have done is I am trying to do Article 14 analogy here. I am trying to equal both parties, both dowry givers as well as alleged dowry givers and alleged dowry takers are on the same pedestal. They cannot be differentiated. That is the first question I am asking in my prayers. I am saying, declare that dowry givers are equally liable for prosecution as much as dowry takers. If there is a dowry transaction, punish both parties. Okay. You don't have any legally sustainable ground on which you can excuse one party and punish another party. As on today, the law doesn't allow for that flexibility. So I raised that as a first question. Now, because of this question, my writ petition became more like a pill. It is not one part. It is not my individual case that I'm fighting for. I'm raising a question of law here. Okay, because of that, what I understood is honorable courts want to hear the respondents also. They want to know what the government will say, because they are at least they are part of the entity, parliament, which passed this law long back in 1961 and made 2 amendments in 1984 and 86. Yeah. Till now, it's been like 30 plus years, 36, 37 years. There is no amendment except for extending this law to entire India. No change has been done. So now, because of this question and the next couple of questions that I raised, Honorable AP High Court is looking at this case more like a public interest litigation rather than one individual's agony. Now,
Right.
as we can see, I'm asking, declare the dowry givers, whosoever it may be. It can anybody who gives dowry. Because going by the definition of dowry, it is not necessary that the parents of the bride should give the dowry. It is wide enough. Anybody could give allegedly the dowry. And when I say can give, I'm not proposing giving dowry, but law says if whoever gives, parents or relatives or guardians of the married woman or the bride, they are liable for punishment. There is no exemption, there is no proviso, there is no non-abstented clause, nothing like that in section 3. So going by that logic, I am asking section 3.1 clearly mandates whosoever gives dowry, they come under the purview of section 3, section 3.1, and they don't have any protection from prosecution, which is defined under section 7.3 of Dowry Prohibition Act. So in a short while, we will see what section 3.1 says and what section 7.3 says.
Sure.
And apart from these prayers, I mean, I'm asking certain directions to be passed to government as well as the DGP, so as not to exclude anybody who allegedly gave dowry. And where is this giving dowry aspect coming from? The complaint of the married woman itself. In my individual case, the woman has clearly stated that my parents gave dowry, or my parents gave certain amount as dowry. They are clearly calling it as dowry. They are not even clever enough to call that as a gift or voluntary contribution or voluntary gift. No, they are not saying. They are clearly calling it as dowry. Either it is ignorance or arrogance of law.
Yeah.
So
Actually, this is
considering,
a
yes,
interesting
Vivek.
point where I think many in the public also are not aware. So many people have this idea that dowry is. I think you have also mentioned in your WP that any upahar or gift which is given later on, if there is a problem in the marriage, that is, at that time that gift is deemed as dowry in the complaint.
Yes.
So this is a confusion. I think 90% of people, or maybe 99% of public, they don't even understand that the gifts which you receive,
Hmm.
it is actually a sridhan, or for the wife. I mean, for the woman.
Yes.
And that is my understanding. If I am wrong, please correct me. And any gifts given to the husband, that is his property. Sometimes
Yes.
it is seen that the woman, she takes away her sridhan, and she takes away the gifts given to the husband also, which is legally speaking not her property.
True.
So
You are
can you say
100%
a
right.
little bit on what is dowry? Because my understanding is dowry means something which you demand forcibly or you force somebody to give. Anything which is given voluntarily is not dowry. It is sridhan or a gift. So is it correct, or would you like to add something
Yes,
to discuss?
Vivekji, that is absolutely correct. Something voluntarily given is called as gift. But the
Okay.
problem here is the convoluted or the wantonly misinterpretation is being given. The property or gifts given to a married woman or the bride is Sridhan by definition. Absolutely correct, no doubt. But the problem is, what about the gifts given to the husband? There is no definition as such. Considering this act was made in 1961, nobody bothered to give definition to other aspects, other terms, other usages, other practices. That is the problem, and the lack of definition is causing this confusion. And frankly speaking, I should not be calling this confusion. It is wantonly there. That is the misinterpretation being given to the law. Now, going by, let me open up my Dowry Prohibition Act. Sorry. I am just going through the Dowry Prohibition Act. So I'll just take you through what the law says. It's a small act, around 10 to 12 sections in the act. Section 2 of Dowry Prohibition Act defines what is dowry. So I'll quickly walk you through the section 2. I'll read out. If you have if the audience have a copy of Dowry Prohibition Act, kindly.
I'll open it on the screen. Let us hope.
Yes, please. Yes, please.
So it will help the people. Yeah.
Yeah.
Okay. So. Okay. I think it's visible on the screen.
Yes. Yes, I can see the screen. Now, going by the definition, let us stick to the definition or the law, what it says, not what ongoing activities are going on. Only then we will be able to question anything in the code. Okay. In this act, the dowry means any property or valuable security given or agreed to be given either directly or indirectly. So that is the actual transaction that should happen. A property should exchange hands or agreed to be given. So for example, if someone says, I'll pay this for this marriage, right? One party says to the another party, that is a dowry. The property's value, earlier it was defined, it was taken away. If you see, there is a stars at that above explanation 1. There was a upper cutoff. So that was removed by an amendment. 1984 or 86 amendment, it was taken away. So there is no minimum or upper cut of any property, valuable security, if given or agreed to be given. That classifies as dowry. And between whom should this transaction happen is given in point A and B. By one party to a marriage to other party to the marriage. Again, party to the marriage is not defined anywhere. So it can be anybody. And again, going by the part B of the definition, by the parents of either party to the marriage. So by the parents of either party to the marriage or by any person. The moment it says any person, there is no restriction. Even a third party, stranger, unrelated to the bride or bridegroom, even if he offers a property, that should classify as dowry. Reading a clear, making a clear reading of the law says so.
So one question here, just to interrupt you. Is it correct to say that if we go by this definition, then any gift given to a husband should also be called dowry as per Dowry Prohibition Act?
Absolutely. Okay. Absolutely. I mean, taking a literal meaning of this, parents of either party to the marriage to either party to the marriage, one party to another party, whoever gives a valuable security, whoever gives a property, that is called as dowry. They are more like they are defining an offense of a defamation. They are defining the offense of a murder, homicide. That is what is given. Who gives, they should be punished. Who takes, they should be punished. First of all, they define the act. Second of all, they define between which parties this transaction should happen. Considering this aspect, now it is not a gender specific law at all. It is a gender neutral law. And again, either party can be prosecuted. I mean, there is section 4 and 5 also we will go through now, which clearly says this is not a gender specific law. Even though the name of the law says dowry, from the definition of dowry, they have made it gender neutral. Gender neutral, right? So, and again, valuable security, the definition is taken from the Indian Penal Code, which anytime soon can be repealed. So section 30 of the Indian Penal Code has certain definition of valuable security. So let's not go into IPC now. For now, we clearly know any property. There is no upper or lower marking cutoff here. If given, it is dowry. It can be a small pen, it can be a watch, anything. Provided it is voluntarily given, it is a gift. Totally out of this act. Totally out of the purview of this act. But if it is,
does it say voluntarily? In the definition, doesn't say anything about voluntarily, right?
Agreed. That is the excuse, that is the exception that the Honorable Court wants to carve out. Even though there is no voluntariness, voluntary word is not there, there is no tinge of voluntariness in the definition or any of the sections. The courts want to give benefit to the woman. That is what the sense I got the other day in the court. The court openly is asking the advocate fraternity, around 30-40 advocates, opening the contention to the entire floor, saying that the law doesn't provide you any exception, but is there any other way from the act or outside the act we can introduce into this provision whereby we can protect dowry givers? I was shell shocked.
Okay.
Anyway, coming back to this, now that we know what is meant by dowry, let us look at section 3 of the Dowry Prohibition Act. Yeah. So the section 3, the first subsection is very, very important. And let me read it out. If any person, again, there is no relation given here, parents, guardians, or anything. I made up that possibilities in my writ petition prayers. But then if it says, if any person after the commencement of this act gives first offense, takes second offense, abets the giving or taking of dowry. So it's a third or fourth offense. The moment these acts are done, there is no qualification under duress if you are given, under threat if you are given. There is no exception that can be carved out. There is no exception can be given here by the plain reading of the law. He shall be punishable with an imprisonment which shall not be less than 5 years. So minimum punishment itself is 5. And with a fine which shall not be less than 15K and the amount of value of such dowry, whichever is more. So having read that, it clearly does not provide any wiggle room, any flexibility or space to introduce voluntariness. You cannot say if you have given the dowry or if you have taken dowry voluntarily or sorry, under duress, under pressure, it is not a crime. There is no way to say that, at least going by these 3-4 lines.
Actually, going by this definition, every marriage is a crime because, and not just one crime. There are like hundreds of people who are committing crime in every marriage.
Exactly.
Whosoever is giving a gift to either the wife or the husband, they are committing a crime of giving dowry as per this
exactly.
law.
This is not a marriage. This is like a gang, robbery or something that is happening. But the problem here is robbery and other things happen to people who have no part of the gang. But here, the gang members itself are colluding and committing a crime, which is a crime from the third person view, outside the third person. The people who are committing this, they're happy to commit it. They're happy to demand, allegedly, they're happy to pay dowry, give dowry, or take dowry. All those things are being done by the people who are happily colluding to do this crime. And whenever someone's marital relationship hits the rocks, their marital relationship becomes sour, that is when they turn this happily colluded crime into a one-person crime. They put all the blame onto one party and then try to showcase the victim card or woman card in some cases, in most of the cases, and then say, I'm an innocent. And this realization hits them only when they go to the police station to register a complaint, not before that. This hypocrisy, until it is comfortable for me in the marriage, I am not going to raise my voice regarding the property given, gifts given, anything given. But my marriage hits rocks.
Just continue, Sandeepji. I'll be back. Yeah, just give me 1 minute.
Sure.
Please continue.
Sure. Thank you. So, people, I hope you are all understanding. Section 3 is a two-way sword. Whoever gives dowry should be punished. Whoever takes dowry should be punished. There is no third way of looking at it. And again, the punishment is more than what 498A carries. 498's maximum punishment is 3 years. But coming to Section 3 of Dowry Prohibition Act, the punishment starts at 5 years. The law says with imprisonment for a term which shall not be less than 5 years. So 5 years and above is the punishment. That is the seriousness attached to by the parliament to this offense. But what is the ground reality? Whether the complaint discloses giving or taking of dowry, the moment a married woman goes to a police station and complains about cruelty to her from her husband or her family members, Section 3 and 4 comes as complementary gifts. There is no need to specifically mention this crime. Right. Now coming to subsection 2 of it. Nothing in subsection 1 apply to. They carved an exception here. Presents which are given at the time of marriage to the bride, presents which are given to at the time of marriage to the bridegroom. So first of all, they made 100% crime. Giving any property is a crime. But then they are creating an exception to the subsection 1. Subsection 2 says any presents given to the bride or bridegroom are exempted. The subsection 1 does not apply to these two presents. Now, nobody, I mean, there is a practice in many of our communities that if gifts are given, they are documented in a list. That is the practice in our Indian tradition. Say in Telugu, in Andhra, we say chadivimpulu. So the well-wishers, the family members who come to attend the marriage, they give some cash or any gift. And I have seen in some marriages where they've set up a mic and announce who is the presenter, the gift, the person who is giving the gift. They will announce so and so Sandeep has given 1,000 rupees as gift to the bride. Okay. They'll announce that, publicly announce that. It is out of happiness, and they want to showcase their wherewithal and how well off they are. They do that. So that practice is turned into 1985 rules. 1985 rules. I'll read out the name of the rules. Maintenance of lists of presents to the bride and bridegroom rules. 1985. It is just a one page, two rules. They are there, and in the sub rule number 2, it clearly says prepare a list of all the gifts given to the bride, and the responsibility is given to the bride only. You prepare a list, or anybody from your side prepare a list the gift item given, nominal value of it, approximate value of it, and the person who is presenting the gift. At least these 3 information should be there in the list. Similarly, the groom, someone has to prepare a list of items, gifts given to him, presents given to him, and a nominal value on the person who is giving gift. So the laws that we are actually currently are suffering are legalized forms of our practices only, frankly speaking. Now these lists are not being prepared ever. I have not seen anybody come up with a list of presents given to bride or bridegroom in any of these cases that I have looked into till now. It's been 4 years, 5 years I'm discussing matrimonial matters. Never I have seen someone coming up with a list prepared during the marriage or right after the marriage. Never.
Right.
Even though that is statutorily, there are rules. The problem is implementation of the rules is not effectively done. Who should do that? All the function halls, all the churches, all the masjids, wherever the temples, wherever the marriages are being conducted, they should be aware and they should follow these rules. They should do it. They're not doing it. So first problem is there, root problem. If you record the lists of presents, and both parties can exchange and countersign the lists. That is also provided. The law provides for it. The same rules, 1985 rules clearly state. I'll just read out the law. It is just a 2-page. Probably I'll share this 1-pager to Vivekji. We can share it.
Maybe I can just put it online.
Yeah, definitely.
India Code.
If you have it.
Dowry Prohibition Rules, 1985, right?
1985. Maintenance of lists of presents.
Okay.
Yeah.
Maintenance of list rules. Okay. Okay, I hope this screen is visible.
Yes, Vivek, I can see. But hardly it has 2 rules, and the second rule is where we have 4 sub rules. It clearly calls out sub rule 1 says the list of presents which are given at the time of marriage to the bride shall be maintained by the bride. The woman or someone from her family, from her side, party to the marriage, they should prepare a list, and that list should contain details of the present. Similarly, subrule 2 talks about bridegroom to be preparing a list. Subrule 2.
Right.
Now, subrule 3 is very clear, very detailed. It says every list of presents prepared either by the subrule 1 by the bride or bridegroom, it shall be prepared at the time of marriage or as soon as possible after the marriage, so that the information is still fresh in our minds, everybody is still present, we can document it easy. Once people give gifts and leave the place, it is difficult to chase them and follow up with them and prepare a list. So they have given this kind of rule here, and it shall be in writing. It cannot be oral, it has to be reduced to writing, and it shall contain what are the information that list should contain: a brief description of each present. Anything. If it is a mixer grinder, you give a brand name, model name, at least nominal price if you don't know the price. Sometimes because we are giving gifts, we ask the shopkeeper to remove the rate label. So nominal value, approximate value, and the name of the person who has given the present. Okay, and where the person giving the present is related to the bride. If that person, the person giving the gift is a relative of the bride or bridegroom, describe the relationship. Mama, mommy, chacha, chacha, whoever it is, uncles, aunts, give a drift. So this is more like a traceability matrix. Who gave the gift? What is the gift? What is the nominal price? What is the relationship with these two people? Person giving the gift and person receiving the gift. Right? And now point D of the subrule 2 says shall be signed by both the bride and bridegroom. So they are making these two people accountable. Yes, I have received these gifts, presents. So both bride and bridegroom should sign. Right? Now, subrule 3 is this. Subrule 4. Subrule 4 clearly says bride or bridegroom may, if she or he so desires, obtain on either or both of the list referred in subrule 1 and 2 the signatures of any relatives of the bride or bridegroom or any other person or persons present at the time of marriage, more like a witness signatures. So if you see, whatever the practice they have legalized under this rule number 2 of these rules, it is clearly to lock people into something that they cannot turn it into something else. This is a gift presentation exercise, and the gift presentation exercise is being documented in the written form. Whoever is giving the gifts, their details, the details of the gift, the relationship has to be documented, and directly the bride and bridegroom has to sign. If that is not sufficient, they are asking for counter signs also. So this is more like a contract. They are putting the practice into a form of a contract. That is why these rules are very important. Nobody is, I mean, most of the people are not aware. Most of the function halls or wherever the marriages take place in India, they don't know about this. As a practice,
but how are marriage halls liable? Is there any rule under the act which says that a marriage hall is liable?
No, it was expected thus these rules will be implemented just like the law. Even in the DP Act, there is no obligation on the marriage halls or functions. What I'm saying is that should be there. Such an obligation should be there. If you are taking 50,000 rupees or 1 lakh and above to conduct a marriage, a function of marriage, and you are providing them all the facilities, food, washrooms, restrooms, and changing rooms, everything, and mandap, everything, you should have minimum legal obligation to conduct in legal fashion. Law says so. Rules have to be prepared. Now, marriage function halls cannot insist on this because they cannot. Hardly their relationship is I take money, I rent you my property for your function.
Yeah,
that's all.
And
right?
that
So
is
that
correct
obligation
because,
is.
Yeah, I mean, until and unless the law gives a responsibility on the marriage hall, I think this is a private thing between the marriage hall and the parties. So why should the government or the lawmakers intervene into everything? Like you should do this, you should do that, and I will make sure otherwise I'll punish this person or that person or whoever.
Exactly.
So
if not,
there is a question. So should we take it now, or do we want to wait till the end of your presentation?
No, I mean, from what I have just now said, I hope that all the audience got a understanding of Section 3 already, where
One
the
person
loophole is.
has raised the hand, so I'm assuming
We
he
can take
wants
the
to ask a
question now.
question.
We can
Okay.
take the question.
Yeah. So yeah, go ahead. SG, you can ask your question.
Sir, this is Sai. Actually, I am also facing this false cases. It is going on. So
Okay.
I have represented the judge and I filed a petition under Section 3 of the Dowry Prohibition Act on the basis of High Court judgment, sir. In 2007, High Court of Delhi has given a judgment. Whoever gives the dowry, they also on them also FIR need to be registered. Even I have
Okay.
filed, but magistrate has raised some objections, and even I have complained to SE and this one, but they are not ready to take. So this is the thing, sir. And one more thing, whatever the sir is saying like mandatory list of presents, including whatever the cash and articles they are giving during the dowry, it should be supported by the IT returns and everything. There should be some valid proof. So even I have filed a complaint with regard to that one, that there is no proper response from the police department as well. Even CP Grams, I have lodged so many complaints. By quoting that one, I High Court judgment also, I addressed it to SP, but there is no
Okay.
concrete.
Which is your state? Which state you are in?
Sir, I am from Hyderabad, sir, but I am facing case at Andhra Pradesh, sir, Anandpur.
Okay.
Okay. Okay. Let me try to answer that question, Sai Garu.
Sir.
The judgment that you are talking about, I hope that is not overwritten, right? First thing. Second thing is, I don't know what is that judgment, so I cannot comment on the validity or the reasoning given by the Honorable Court, Delhi High Court in that judgment. What I understand is you are knocking at the doors of all the forums which do not have an authority to interpret the law. Interpreting the law is exclusive domain of constitutional courts, which are high courts and supreme courts. All the trial courts, district courts, magistrate, and other courts, all other forums like RTI, all those things cannot interpret the law. They can follow the law established by the other higher courts. So, if your Delhi High Court judgment clearly says register an FIR on people who have committed the crime of giving dowry under Section 3 of Dowry Prohibition Act, please use that and bring this. If your case is in Andhra Pradesh, knock the doors of the AP High Court saying that Delhi High Court said so. It has a persuasive value even in Andhra Pradesh, because both they follow what Delhi High Court says in Andhra Pradesh High Court. You can convince the court, AP High Court, to follow Delhi High Court. If you have already tried that, what is the outcome? But
no, I didn't try with High Court, sir.
okay.
I only tried.
So through this
I tried
forum,
only Quad.
Sai Garu, through this forum, what another agenda item that I have is, I want to encourage all the people who are facing Section 3 offense in their FIRs, knock on the doors of AP High Court, take help from my petition. All the paragraphs in my petition are not specific to my own case. They can be easily copied and pasted into your petitions. Go and file petitions in the Honorable High Courts. Ask them, how is this acceptable to punish one party to a crime and exempt another party to a crime? What is the basis? It is hitting Article 14. It is hitting Article 21. And frankly speaking, it is in a way also violative of Article 15.3 also. What does 15.3 says? It says the Parliament can make laws for women and children. Okay, they made a law for women, Section 3 Dowry Prohibition Act. Very good. Who is getting punished here? Mother-in-law also is getting dragged into the case. So both of them are women. One law made for the benefit of one woman is causing inconvenience and discomfort and heartburn to another woman. How is it correct?
But subsequent judgment also has come, but I don't remember. Since woman is the victim, you cannot file a dowry case on her. But her father and the brothers who are giving statements that we have given dowry are very much very.
That is why I'm saying that is my request to you is, if these people are openly admitting to something, a crime, frankly speaking, don't stop them. Don't stop them. Let them say it in all the documents, complaint, 161 statements, anywhere,
Yes.
chief examination, wherever, let them tell that.
Yes.
Then use that deposition, use that legal documents before drag them to the Honorable High Court. Simple
One
question.
more thing I want to add, sir. These people, what they are doing after the trial in judicial magistrate, this one. So they are simply removing the dowry and they are convicting the accused under 498. Because what I have seen, some judgments I have gone through in Anantapur court
Okay.
system. Since
Mhm.
if they give punishment under dowry prohibition, then prosecution against the wife also will start subsequently.
Mhm.
So this is the procedure it is getting followed, sir. What I mean.
We all know how police operate. I don't want to go specifics, but we know how police manipulate FIRs. If they
Yes.
require,
Yes.
they will put a section which carries punishment more than 7 years if they want. If they
Yes.
want, they will
Yes.
dilute the case by removing certain sections after in their charge sheet. So police
Yes.
have that flexibility and they are using it to the 100%. Our duty starts whether the FIR and charge sheet are properly prepared. If not properly prepared, you have the legal remedies of quash and discharge as appropriate.
Yes.
Right? That is
Yes,
first
sir.
thing. Second thing is if Section 3 offense. I'm focusing this conversation again, bringing back it
Yes.
to Section 3. If there is Section
Sir.
3 in your cases, don't make any effort, waste any effort on talking to the police, talking to the magistrates. They cannot do
Hmm.
it. They
Yes.
are they are conditioned for years, decades together that moment a married woman goes to a police station, there is a package readily available to them. Recently,
Yes,
just
sir.
2-3 days back, I think Honorable
Uh,
Madhya Pradesh High Court also talked about package of 5 cases. They have used that
hmm.
phrase.
Yes.
They have used that phrase of package of 5 cases. All of us know what is 498A, MC, DVC, divorce. And probably
Yes.
they are talking about RCR also. That is a very
Hmm.
funny and peculiar thing. In one hand, the woman is asking, punish my husband for 498 offense, Section 3 offense. On the
Sir.
same hand, on the same breath, the same woman is asking, I want my husband back in RCR, Section 9. That is
Hmm. Hmm.
contradictory. That is hypocritic. You can't ask your husband and also send your husband and his family members to the jail. Correct.
Correct.
So,
Correct.
if these people are doing these kind of nasty things, first thing is don't lose confidence. You are not in the wrong if you have not committed any crime. Don't be in
Yes.
that victim mindset at all, please. You just
Sir.
have to gather your courage, fight back
Sir.
legally speaking, and approach the right forum. For all
Hmm.
RTIs and etc., go to the appropriate forum, no problem. For tax evasion, go to the appropriate forum. But if there is a question of law involved, trial courts cannot decide that. They don't have power.
Hmm.
High
Hmm.
courts have the
Correct.
power under 226, under 227, if there is an interpretation of law. I will slightly digress. In Dowry Prohibition, Domestic Violence Act, there is a provision, Section 12.5, which says 60 days. We say 60 days to be disposal. So try that. If your case has already stretched for 1 year, 2 year, 3 year, and there is nothing wrong from your side, you are appearing to the court every day. Ask the Honorable High Court to implement Section 12.5 in my case.
Hmm.
Okay,
Hmm.
so I mean, coming back to Section 3, wherever there is a question of law involved, interpretation district level people, including the magistrate and the police, alleged dowry givers in the FIR as accused. Why are they becoming innocent victims? LW2, LW3. How? For example, if I commit a crime of murder and go to the police station and disclose that I admit that I murdered someone, please don't consider me as accused number one. Consider me as listed witness number one. How hypocritic is that? Silly.
Hmm.
Correct. That is
Correct.
what is going on. So it is my earnest request to everybody, whoever is suffering Section 3 Dowry Prohibition Act section in their FIRs, please bring this to the notice of the Honorable High Courts. My petition has all the necessary information. Take it, download it, use it in your petitions, prepare your own petitions, approach a capable lawyer who can take this forward into the Honorable High Court in your state and raise this question. I have done this in AP High Court. Why don't we all do this in various High Courts? We can do
So,
that.
Sandeep ji,
And
yeah, sorry to interrupt.
yeah,
I
Vivek.
think probably now is the right time to discuss what is the why does it happen. Maybe you can talk about subsection 7.3,
7. Yes,
so
please.
that people are aware that
Yes, please.
because what I don't want is that like I want people to have the right legal knowledge, but what I don't want to happen is that they become highly excited after hearing your comment and they start filing some petition, and then later on they read subsection 7.3 and then they say that why didn't
They
you tell
get
me? What is
disappointed. Yeah,
subsection?
I understood.
Yeah.
Understood.
Okay.
Let's look at section 7.3. Vivek,
Okay. I'll
kindly
just
scroll to that.
drag it down.
Friends, if you read section 7, it talks about cognizance of offense, right? And it starts with notwithstanding anything. Subsection 1 says. Similarly, subsection 2, nothing in this section. So all these three subsections are called as non-obstantive clause. That means it is like an overriding power, right? It is like an overriding power. And what is it overriding? Rest of the things in this act. In this small act, there are certain sections. This section and subsections in section 7 are having a power of overriding whatever is said in the other things. Now let us look at subsection 7.3 here. It starts with this word, notwithstanding anything. So it's called as non-obstantive clause in legal terms. It has an overriding power, notwithstanding anything contained in any law for the time being in force. So let us understand that first phrase. It's a lengthy phrase. Notwithstanding anything contained in any law for the time being in force, meaning whatever be the law currently in force, it is being executed in India, notwithstanding anything in such an act. Any law has certain force, right? Force of law. So notwithstanding anything, the next portion of it is very interesting. A statement made by the person aggrieved by the offense. Again, who is the person aggrieved by offense? There is no definition as such here, but the same phrase is available in other laws also. CRPC there is, I think Evidence Act there is one phrase. So a person who is suffering the consequences of a crime, we can say like that. So in this act, a person aggrieved by offense is not defined. So what will courts do? They will make out an intelligent meaning out of this phrase. Okay. Now, person aggrieved by offense, we'll come to that. Who can be called a person aggrieved by offense? But before that, it says a statement made by such person shall not subject such person to a prosecution under this act. For example, I give a dowry, right? And I go to the police station and I make a statement. Now, there is no definition what is meant by statement. Is it a police complaint? Is it statement under 161? Is it statement under any of the many sections in CRPC? No clarity here. It simply says a statement made by the person aggrieved by the offense. So to my mind, I am hoping that a person who is facing the consequences of a crime, if such a person gives a statement, he or she should not be prosecuted for any of the offenses in this act. Okay, considering this as a go-to law, police and magistrates and even 7 high courts have used this subsection to exempt prosecution of dowry givers. Even though a married woman, the bride, clearly writes in her complaint, makes a clear admission in her 161 statements, and why not? She might come to the honorable courts in chief examination later in the life of the case and clearly say, I have given dowry. She is considered as a victim here, a person aggrieved by offense here. Okay, that may be a possibility, and there is a one judgment by Delhi High Court which says she is an aggrieved person. She is suffering the consequences of a crime under this act. So she cannot be prosecuted. Her statement should not lead to her prosecution. She is a victim. All right. Now, Vivekji, scroll a little bit above. We'll look at subsection 1. Subsection 1. Now, friends, please focus on subsection 1B2. Okay, I'll read it out. No court shall take cognizance of an offense under this act. No court should take up a case except upon its own knowledge or a police FIR or a complaint by person aggrieved by offense or a parent or other relative of such person or by any recognized welfare institution and organization. So to paraphrase this subsection says, don't entertain any case, don't accept any case, no court should take up that case provided unless a complaint is given by three people here. I am clearly calling them out, three people. First person is person aggrieved by offense, a person who is facing the consequences of the crime, who is suffering. That person can make a complaint. Second person is a parent or such relative, other relative of such person. For example, this person is hospitalized. They are not in a position to make a complaint. Maybe they are dumb. They may, I don't know. Maybe they are in a situation where they are unable to make a complaint. They are in coma, for example, or what? Or maybe they are outside the boundaries of India. They are not in a position to make a complaint. So, a parent or other relative of such person can make a complaint. That means this person aggrieved by offense is totally a different person than a parent and relative. Both of them are not same. They are two distinct people, different people. The third entity who can make a complaint of dowry prohibition under Dowry Prohibition Act is an NGO, whoever is a welfare organization who is working for the cause of destitute people, unfortunate and poor people. Such an NGO can also make a complaint. Now, this law clearly calls out three people: person aggrieved by offense, parent or relative of the such person, and NGO. Now, exemption under subsection 3 is given only for person aggrieved by offense, a victim person, not to that person's family members or relatives. A combined reading of subsection 1b and 3 gives this meaning. Unfortunately, even this interpretation, what I am trying to make out, is also nullified by another high court. That second high court clearly says parents of the women aggrieved by offense under this act are also innocent victims. You're getting my point? So the courts, honorable high courts, constitutional courts are blatantly misinterpreting the law only for one singular objective: to protect the family members of the woman. That is the agenda. So they have a personal bias, in my opinion. I'm not taking any one high court here. Most of the high courts that have passed orders, it clearly reflects in their judgments that someone is to be protected by hook or crook, by whatever way of misinterpretation. Let us protect them. So these judgments, which I'm mentioning here in the are listed in my petition, as well as the page that Vivek has been showing till now. So all the judgments are there. All of them do not answer a question. If parents of the bride are innocent people, bride herself is innocent people, the relatives of the married woman bride are innocent people, who should be protected for the offense of giving dowry? Did that not take place at all? The offense took place, but nobody should be prosecuted for the offense. So this hypocrisy is what I am questioning in the first prayer of my petition. I am asking, dowry givers and dowry takers are equally liable for punishment.
I have one question, Sandeep ji. Basically,
Yes,
by reading of subsection 7.3, which says that anybody who gives a statement that he's a aggrieved person,
yeah.
let me just 7.3, I go to that. Statement by a person aggrieved by the offense. So let us say the complaint is filed by the wife that dowry has been forced on me and my family. Subsequently, the family members of that person, of wife, basically her parents, they also give statement to the police that on such and such date, my daughter called us and she said I've been harassed. Whatever, there are certain kind of statements which they have given. So wouldn't it kind of reading of this subsection 7.3, it will kind of make them immune from any prosecution because of this, legal, the how this is drafted. All you have to do is give a statement to the police or somebody that I am a aggrieved person. I'm a victim.
that they are using. I think I lost you, Vivek. Can you please repeat last what you said?
Okay. So my question is, I think your one of your major arguments in the PAL, which you explained now, is that the woman, the wife, has given complaint of dowry, harassment, etc. But
Yeah.
it doesn't exempt her parents from prosecution as accused of dowry giving crime.
Yes.
Now, my counterpoint is that as soon as the parents of the wife they give a statement to police, during CRPC 161 or whatever section, that yes, we were also harassed for dowry. The
Mm.
opposite party were harassing my daughter, and my daughter was complaining to me. So,
Yeah.
see, I mean, it is not like your daughter is being harassed, so she's putting the pressure on you. So you will say, okay, I'm also being harassed. So I'm a aggrieved person. Is that a
Yeah.
valid interpretation as per
Yeah.
7-4?
It is. Uh, yeah. I think Advocate Paritosh. I think this noise is coming. Can you please go on mute, sir?
1 second, I'll mute.
One may argue that the lady will get further aggrieved if her parents are prosecuted.
Agree, sir. Let me answer those questions. I mean, I'm taking all those questions. All of them are arguments that I anticipated and addressed in my petition. I'll answer them. The first thing, the parents of the married woman, the bride, calling themselves as victims of or aggrieved persons under this act. So they have become aggrieved persons not today, the day they have given the dowry. They have succumbed to the alleged pressure or demand from the groom side. The action that they should have taken at that point in time is to go and make a police complaint under Section 4. Someone is demanding me of a dowry. Section 4 does not discriminate between before marriage or after marriage. So, before marriage or after marriage also, the course of action the parents of the bride should be taking is Section 4 complaint. That they have not done. This, in a way, is condoning the crime, or frankly speaking, participating in the crime. So someone who participates in a crime cannot take the shelter of Section 7(3) saying that I am aggrieved now. What were you when you were giving or participating in the crime? You are a criminal. When it is convenient for you, you do the crime and become criminal. When it is not convenient for you, you turn your argument and say, I am a victim now. I am exposing this hypocrisy before honorable high courts here. This is first point. Second thing is, even after marriage, if someone there is a demand, alleged demand of dowry demand, even then the course of action is not 498A or Section 3. They should be going. They should not be succumbing to the pressure of dowry demand at any cost. For example, I'll give the life cycle of this chain of chain of activities. What action actually happens first? Demand of dowry. Allegedly, demand of dowry happens. What is the next action that happens? Giving of dowry. Next action that takes place is taking of dowry. What is the best spot to arrest the dowry offense? Demand of dowry. Why do you succumb to the dowry demand for dowry and then come to Section 3 later? Getting my point? So my question to the honorable courts is, there is a hypocrisy that is happening. When it is convenient to me, I will give dowry. When the marriage hits rocks, marriage hits trouble, then I'll call the dowry aspect, so the gift aspect into dowry. So this hypocrisy, I am asking the Honorable AP High Court to clarify. Is this okay? At the time of marriage, we'll give dowry. At the time of making a complaint, we'll call we'll call that as we'll call whatever is given earlier is a gift. So this double standard is what I'm questioning before the Honorable High Court. So such persons who become innocent victims now, but earlier were criminals, complicit to the crime, cannot take advantage of Section 7(3). If they have not committed any crime, yes, they can be victims. So this is very subjective and it cannot be rigidly applied to all cases of Section 3. That is my argument point. So I'm asking the Honorable Court to decide whether this kind of hypocrisy, this kind of double standard and double speak can be allowed. Right? So that is my answer to people who raise the questions on parents of bride are victims theory. They are not victims of theory. And subsection 1 point B clearly calls out these two are not same people. They are distinct people. And on a lighter note, I would ask all the members here, after the marriage, if these parents and girl, the bride are one and the same, who is going to the matrimonial home? Only the married woman or उसके साथ मम्मी पापा भी जा रहे हैं? वो तो नहीं जा रहे ना. So only the girl is going. So that means these are not same people. They are not agreed persons by default. Just because the girl is victim of or person agreed by offense, her parents cannot be clubbed with her.
I think that's an excellent point. And if I might add, it is, if it's only hypocrisy, that would be one thing. But what I have also observed in cases which has come to me is it is more like, pre-planned kind of, conspiracy, because I know of a case where deliberately, without even, asking permission of the husband, they transferred some money into his account. They knew his bank account number and they transferred some money. And they may have given some excuse that this is meant for, this purpose, that maybe furniture or in your house or whatever. Later on, they will say, okay, this is a dowry demand, and that's the reason we were made to transfer this money.
Correct.
So
and they are taking a
kind of, it's much worse than hypocrisy, which is at least it has a little bit of, okay, you have some excuse or you can try to get away somehow. But
yes,
it is
and
not like we want to
they are
punish you.
getting yes, Vivek, and they are getting the courage to this kind of criminal thoughts because of section 8A. Can you please scroll to section 8A? Burden of proof in certain cases.
Let me just open that.
Yeah. So it's a very small subsection. It says where any person is prosecuted for taking or abetting the taking of any dowry under section 3 or demanding of dowry under section 4, these two sections, the burden of proving that he had not committed an offense under those sections shall be on him. This is basically reverse burden of proof. There is a phrase used, reverse burden of proof. Generally speaking, 99% of the cases, the burden is on the person who is making a claim, making an allegation. Someone hit me, someone demanded me, someone threatened me. Whoever is making that assertion has to prove such thing happened. But in the law, if you see, this is a 8A, that means it is brought as an amendment parcel. If you scroll a little bit, we can see it is brought by 1986 amendment. 86 amendment. So, prior to that, there was no such burden. And people who are not well versed with the law think that, okay, just because of this, I have a scope to make allegations and don't have any burden of proof. I think so. But reverse burden of proof always calls for establishing the fact of such crime happened, and then the burden shifts. That shifts to accused person. Then he has to say, yeah, no, I have not committed the crime. I have not made that demand. They might have transferred some money into my account. That's there, but there should be some pre and post activity that should happen.
Okay.
There should be a demand prior to transfer, and there should be some kind of confirmation after the transaction. It's just like I'm going to a bank and making a transaction. Before that and after that, there should be some activity. The prosecution has to establish that here is the demand. Just because section 8A says I don't have a burden to prove, it's only the accused person or the husband who has to prove. That is not so. The law is very clear. The Honorable Supreme Court has in multiple cases explained reverse burden of proof, saying that first you establish dowry taking, abetting to dowry taking happened. Someone abetted taking dowry, someone took dowry by way of witness or by way of electronic evidence or paper evidence, some kind of evidence. Or if it is a cash, someone has seen giving of dowry, someone taking dowry. Very good. Establish that first. Then husband's prerogative becomes that money that I have taken as established by the wife side is not dowry. It could be a consideration for any other transaction but dowry. So this is how 8A actually plays out. But unfortunately, this true meaning is not understood by many. So they think 8A clearly says putting burden on me and I am doomed. No, that is not the case. Section 7.3 does not protect anybody other than the married woman. Going by various scenarios possible. Who are the stakeholders here? The married woman, married man, parents of married woman, parents of married man, relatives of both sides. So like there are 6 to 7 parties are there.
Okay.
Who are the aggrieved persons here? There is no clarity.
Right.
There is no clarity. At least by within the law, there is no clarity, and the interpretation burden is on the honorable high courts and supreme courts. They try to make out some meaning, and that is haphazard. People say that in Delhi High Court judgment, husband tried to implicate wife, saying that you gave me dowry. But Delhi High Court says she got exemption because she is aggrieved person. But Honorable Delhi High Court did not quantify a dowry transaction hua ki nahi. If that happened, who gave the dowry? The wife cannot be prosecuted, but her parents could very well prosecute. This did not come out in the Honorable Delhi High Court judgment because that question was not posed to the court, unfortunately. So that is the lacuna, that is the gap, and that is the loophole people are trying to advantage. Unfortunately, based on that Delhi High Court judgment, we all know that judgment. I mean, it is available on the website also in the same page. Because of that Delhi judgment and relying on the Delhi judgment, Rajasthan and Orissa and other high courts falsely understood the judgment. Delhi High Court said only one thing: wife is an aggrieved person, she cannot be prosecuted, mister. That is what High Court said. And other high courts extrapolated that protection for the parents of the woman also. Even her parents also aggrieved persons. That is how step by step, judgment after judgment, that understanding crumbled like anything, and we are suffering the consequences. So this is what I am questioning. Honorable AP High Court is well aware that in the law, in this 12 to 13 sections, there is no protection for parents of married women or relatives of married women. Married women can be protected, but still Honorable AP High Court is looking at opportunities or scope of carving out exception whereby parents of married women can be protected. And for this precise reason, respondents in my case have not filed any counter. Not even one of them. Of course, there will be only two counsels. One is the Solicitor General representing Union of India, and Honorable Government Leader representing the rest of the three respondents, state government. Either of them could not file counter till late because they have to take a stand whether dowry giving is a crime as per section 3(1) or dowry giving is not a crime as per what?
Right.
Probably as per section 7(3). That stand has to be taken by the respondents. This is what all of us have to do. Whoever is facing section 3, they should question the state high court asking the very same question. Kindly clarify this. And again, Article 226 writ petitions have wide scope. It clearly says not just for fundamental right violation, for any other cause. Article 226 ends, sub-article 1 ends with this, for any other cause. So we can very well bring this dilemma or the confusion to the Honorable High Courts and put the burden on them. Your Honor, if I and my parents are accused persons in an FIR for the offense of section 3 for the crime of taking dowry, we are accused.
So
well and good.
We have few more questions. So maybe we can proceed one by one. So I think the first person who has raised hand, please ask your question.
Hello, my name is Hari.
Hi, Hari.
Go ahead.
I am from Andhra Pradesh. Generally, we are seeking to register FIR on the based on Section 3 on the opposite party, right? So, in order to get this legislature's attention, can we seek something like to remove from Section 3 whoever is giving dowry? It is not crime at all.
That is the scope of Parliament, right? We cannot ask courts to do that.
Okay.
We cannot ask the question. What I'm asking, let me answer that question in a short way. I am asking the Honorable Court, AP High Court, saying that either decide dowry giving is equally punishable as dowry taking, allegedly.
Okay.
Or if these two things are different, they are on a different levels. I'm asking, declare that dowry giving is not a crime. I'm not asking the court to change anything in the law. I'm asking the court to read it down. Reduce the importance of giving dowry, so as that it becomes not a crime.
Okay, but we have seen we have seen this marital rape exception 376B, where this some organizations have filed petitions asking to remove that exception in marriage, right?
Mhm. No,
But they are not directly approaching
no.
legislation, but they are approaching courts, right?
Let us let us use right words. They may not be asking removal of anything because the courts doesn't have power to remove anything from law. They can
Okay.
read down, they can strike down. Even though the words stay in the law, it will not have any effectiveness. For example, in
Okay.
the DV Act, if you see DV Act, section 2Q, it says adult male.
Okay.
Definition of respondent, adult male, these two words. But in a landmark judgment, Hiral Harsora judgment, Honorable Supreme Court said, by adding these two words, you are discriminating. Not an adult, a juvenile person, a minor person cannot commit domestic violence. He can very well connect, he or she can connect. And
Okay.
again, female persons cannot commit domestic violence. They can commit. So using these two words, adult male, is violating Article 14 and 21. That is what Supreme Court took a stand. So they read down, they strike down those two words.
Okay.
Similarly, I am asking Honorable AP High Court. AP High Court, mind you, is a constitutional court. They have same powers as much as a Supreme Court in striking down, reading down provisions. So I'm asking the Honorable High Court, if you, Vivekji, if you scroll down, scroll up to section 3, please. Section 3. Yeah, if you see section 3, it says if any person gives or takes or abets the giving and taking of dowry. So that is the phrase. I'm asking the Honorable Court to read down giving and abetting to give, these four words. Read down. Thereby, effectively, even though the words are there, they will not carry any meaning, any effectiveness. Thereby, section 3 remains as if any person takes or abets to take dowry. So, I mean, what you and I want is the same thing, but using the right words. I'm not asking the court to remove anything.
Okay.
Or come up with something new. I'm asking reduce the meaning of these words to zero.
Okay.
Make them ineffective. That way, whatever be the agenda. And now, why will you do that? I'm asking what is the basis of reviewing this? Because every law, when it is made in the parliament, the minister introducing the law or amendment gives reasons. The reasons are contained in a document called a Statement of Objects and Reasons. It's a technical document. It says why I am bringing this law. Recently, IPC, Evidence Act and CRPC are modified, and the Honorable Home Minister gave reasons to the Parliament why I am bringing these three laws. It's called a Statement of Objects and Reasons. What is the objective? What is the reason why to bring this law? Similarly, for DP Act also, there is Statement of Objects and Reasons. 1959, Minister Ashok Sen has introduced this law at that time. The first line says, to eradicate the menace of giving and taking of dowry, we are bringing this law.
Okay.
What does the word say? Giving and taking. They did not say taking. So if the intention of the legislature, the parliament, is to punish both people, why punish both people? To create some fear. Don't give dowry.
Yeah.
And face the consequences later on in the life of your daughter. Don't do that. Don't take dowry. Don't suffer criminal cases like 498 later on in your son's life. Don't do that. So Parliament's intention was that. That is why they framed that Statement of Objects and Reasons, and taking that Statement of Objects and Reasons as guiding principle, they framed these sections.
Okay.
That is my principle, wherein I am confident that High Court cannot take a stand that giving dowry is no longer a crime. They cannot say.
Okay.
So they have to say they are equal. Giving and taking of dowry is equal. Since High Court knows they cannot dismiss my prayer, they are trying to find loopholes, exceptions. One senior advocate, just to bring one senior advocate even brought up something called as negative rights. He said, Sandeep, if you want, you can ask your parents to case to be quashed. They have no role to play in the case. But then you cannot say punish that person who gave the dowry.
Okay.
That is the stand learned senior colleagues are taking in the high courts. This is a dilemma that has to be decided by the honorable constitutional court. So I am requesting everybody to drag this matter to high courts. Thank you, Hari.
Sure. Thank you. Bye.
Vivek ji, any other question?
Yeah, there is one more question. Yeah, please ask your question.
Sir, actually, what is the place of occurrence, sir? Because to book any case, place of occurrence is a major thing. But nowhere the jurisdiction and this one, it is not getting fixed. Many of the cases, husband and wife are working in different cities, but the wife is booking cases at their native. So in this case, even in order to attract these dowry offences, there should be some jurisdiction also, right? If wife and husband are living apart, there should be some arrangement or the phone. In this case, what is the jurisdiction, sir? This is my question. Second question is
Okay.
that as a new BNSS bill, I think only because I have gone through, I have not gone through fully, sir, but it speaks only about the dowry test. There is no speaking about the dowry provision or this one. Whatever Dowry Prohibition Act 1961 is there, it doesn't contain type of things in BNSS bill.
Okay, let me answer
So
that.
if the bill comes into effective, whether it will be prospective or retrospective.
Okay, let me answer the first question first. With respect to jurisdiction, jurisdiction is a aspect covered sufficiently under CRPC. Currently, what we have, right? I think 167 or 169 onwards, there are good amount of sections talking about jurisdiction of a crime. If a particular, this is a special act. This is called a special act made for a particular purpose. If this special acts do not have a provision for a particular thing, time limit, jurisdiction, etc., who is the competent authorities, these kind of things, we have to fall back on general law. General law is CRPC, CPC, Evidence Act, etc. Now, CRPC, since it has clearly called out, if a crime, all the crime is local. Wherever that crime happened, that court or the police station in that locality has jurisdiction. That is one section. Next sections clearly call out if a crime happened in multiple places, any one of those cases locations can take cognizance of the case. Third CRPC section says consequence of crime. Someone committed a crime in place A, but the consequences are occurring in place B. For example, someone poisoned water in one place, but the crime happened, someone died in a different place. I mean, take a very random example. So those both places have jurisdiction. Similarly, taking that discussion to Dowry Prohibition Act, wherever this dowry transaction happened, if it is an online transaction, I am sitting at one place, the dowry giver, the father or the relative of the wife or the bride is in a different place, city, and he transfers some money to me. Like the example Vivekji quoted. Both of these places can have jurisdiction, nothing wrong. So he initiated one transaction in one place. The transaction culminated or ended in another place. Money got deposited in a different branch of the bank. So both places have offense. This philosophy applies to our Information Technology Act offenses also. Many of those offenses happen online, where the recipient and the perpetrator reside in different cities. So to answer your question, jurisdiction is sufficiently taken care by CRPC, not in this act. So what is the second question?
Second question, sir. BNSS bill, if it is going to be affected shortly, whether the pending cases we are facing under
That I
old
cannot
act.
answer. I really cannot answer that, because when the act is passed, if you said you have gone through that sufficiently, but not entirely. In the law itself, they provide a provision to retrospectively or prospectively apply the law, right? And again, we know thousands and thousands of cases are still on the books of police and courts. So they will have a provision to accommodate those cases also. Just because they are bringing a new law, the old cases cannot go away. They should make a provision to accommodate all those existing cases. So let us wait for the parliamentary joint committee to give out their response. A lot of work is involved. So when that comes, we'll see. I am hoping that it will be retrospective, because a lot of cases are there. They will get away by filing fall cases. Even the old cases have to be taken care. So let's wait for the parliament to do their activity.
Okay. So Sandeep ji, there is a question in the chat box. I will read it out.
Yes, sir.
This is basically based on the gender neutrality of the Dowry Prohibition Act. That seems to be my understanding on the first reading.
Yes.
It says that, I'm a husband and I was forced to give dowry jewelry to girl and her parents and threatened to withdrawal from marriage ceremony if their demands are not fulfilled. So basically, the wife side is threatening the husband that you give jewelry to girl, otherwise there is no marriage. So, so the question is, how does the following allegation by man fit in framework of law when he is complaining about it? So he's the first person to complain that I am being forced to give dowry to the girl side.
Okay. So to answer that question, obviously 498 may not come into the picture, but yes, section 3 and 4 squarely applies to this circumstance. Not just that, there is intimidation, threats, coercion, a lot of things are happening. All of them are sufficiently covered in IPC. So in my view, I am looking at a case. I mean, this may not be registered by the police as an FIR because they will be perplexed, they will be surprised and shell shocked to see this kind of complaint come. So we may have to go to the magistrate courts to get an FIR registered through 156.3 or CRPC, etc. But the way I'm looking at it is, it has IPC offenses and it has section 3 and section 4 offense also. If can we now scroll to section 4, please? I'll try to answer section 4. We understood that section 3 is sufficiently gender neutral. Let us look at section 4. Demand for dowry. Penalty for demanding dowry. Sorry. So let me read it out. Any person demands, there is no qualification who that person is. Any person demands directly or indirectly, either face to face or through any other medium, from the parents or the relatives or guardian. 3 people, from the parents, relatives or guardian, if the person is a orphan, guardian of a bride or bridegroom. So demand is being made to any of those relatives, parents and guardians of a bride or bridegroom, as the case may be, any dowry. So the demand is for dowry. Dowry's definition is given in section 3. So we know it is a valuable property, a valuable security or property. If someone demands property, that person is punishable for shall not be less than 6 months, may extend to 2 years. So applying this law's interpretation to the scenario that you gave, the husband has to file a complaint of section 3 and 4 because even he is a victim there. And that is the funny part, Vivekji. Person aggrieved by offense is not defined. It is going by a general understanding of the society. Women is the victim. Women is the aggrieved person under this law also. That is a convoluted or misinterpretation that is perpetrated.
Yeah, that is a misinterpretation, because I know of an actual case where the husband, he's taking guidance from me over time, and he said that actually he was forced to give money to the wife's I think sister or brother-in-law, something like that, before marriage, and some money to the wife also. So I can't explain the full circumstances.
Understood.
Because he had some limitation, and that's the reason he was forced to give that some.
I understand. In the face of Vivekji, in the face of honey trap marriages, section 3 and 4 clearly apply to men also. They can also register complaints. In the guise of marriage, there are some people who extort and loot money. In the short span of 1 month to 3 months, they will file 498 dowry prohibition divorce. The agenda is to loot the people. I have personally experienced one woman, experienced the circumstances of one woman who is a serial marriager. She marries one after another. In the third husband exposed her. He did some researching about her online and found out she was already married to 2 other people at a different points in time. And the worst part is she did not divorce the earlier husbands also. So nobody is bothering about legally terminating a marriage and then moving on. I mean, nothing wrong in moving on. Only thing is you terminate your legal relationship, marital relationship with your husband, and then move on and marry anybody. No problem. But since the agenda of these people is to honey trap people, get them into a sham marriage, extort them under the gun, they say, right, at the butt of the gun, and then in the event the husband, the new husband, turns out to be a strong nut to crack, they go ahead and launch cases. So in those circumstances, money is being demanded by women here. So Section 4 applies. Money
Yeah,
or
I mean,
property.
yeah. I mean, I probably won't use the word honey trap. That's used for,
Yeah.
generally spies, so who are trapped by the opposite side. So it's more like a sham
And
marriage.
again, we have come across all these sham marriages on news many times.
Yeah,
And
these are
again,
quite
these
common.
fall trap. Yeah, these people fall trap on the matrimonial marriage websites.
Yeah.
They
Yeah.
give their credentials like I am working for some government organization, some secretive government organization. I can't disclose my employment. And then sometimes husband, the would be husband could be a second marriage guy or a third marriage guy or a widower. So they may have their desperation. So they get into the marriage, unfortunately falling in the
Okay.
traps and losing patience, their money, their sanity, sometimes their life, unfortunately.
Right.
Sir,
So,
one more question, sir.
you can ask
Yeah.
the question.
One small apprehension that, sir, whether 498 has been carved out due to this dowry or it is a separate one, sir.
I didn't get the last portion of your question. Is 498 carved out as yes?
498A has been come into force due to this dowry or 498 is a separate thing, whether it is completely separate one.
It came in.
I mean to say,
Yeah, understood. The 498A, again, going by the A in it, it is an added section. It was added in 1983. There was a international covenant just before, some years before 1983, wherein India agreed that we will make laws to protect women, to safeguard protect them from any discrimination or cruelty. So India agreed to that covenant, became a member and agreed to the covenant. So they had to make a law. At that point in time, they found cruelty. There is no section in IPC, Indian Penal Code General Law, to prosecute someone who is committing cruelty to his wife. So they had to come up with this offense. If you see, there are different offenses against marriage with respect to marriage already in the IPC from 1860 onwards, which are 493, 494, 495, 496, 498. So like bigamy, adultery, etc. Lot of sections. So this particular was missing because this cruelty happens within the setup of a family. Rest of the offenses can happen outside the family, like bigamy. Someone is trying to or marrying you, withholding their earlier marriage. So these marriages were these offenses were already there in the IPC. This 498 offense, cruelty against a married woman, was not covered. That is why they had to bring in. One reason is that. Second reason is international covenant. India being part of the international covenant, they had an obligation to make a law. For these reasons, they made that 1973 amendment to IPC to bring about 498. And again, similarly, they brought amendments to CRPC and Evidence Act also to accommodate all this cruelty to married woman aspect. Thank you.
Okay. So I hope the questions are over. So,
Yes, Vivek.
and I think one person was asking about the PEL link. I have sent it in the chat box. I will share in the Telegram group also.
Sure.
So everybody should be able to go through it.
Wonderful.
And so any other points, Sandeepji, you would like to make?
Yes, one last point is, it's a general statement. Even though one may not have committed dowry offense, if they have committed offense, it's a very uphill task for them to safeguard themselves and their families if they have committed. The only other way out is to settle the matter with the married woman. If you have not committed any offenses, please fight back. Don't be in the victim mindset. Fight back legally speaking. Approach competent advocates. Take help from in number of men's rights organizations. Do not get into that mode of leaving the job, leaving the business, suicides. Don't do all those things, please fight, take support. There are many people, they are doing innumerable amount of service free of cost. So that's my prayer to everybody who is listening in. Fight legally, The laws are biased. Everybody knows that. Courts very well know that laws are biased. It is just waiting. The honorable constitutional courts are waiting for the right petition to come before them. They cannot make Sandeep or someone or Vivek ji or anybody to file cases. It is we who have to bring certain matters which we know are wrong. Bring them to the honorable constitutional court's notice. Draft your petitions properly. Fight legally. Don't think that you will not win. Yeah, you may not win immediately or next year or next year. If you look at my petition, this is filed in September 2021. Correct, rightfully speaking, it's been 24 months. I am constantly going to the court every hearing asking for the counter from the respondents. The counter is not filed. Why do you think Union of India, who is bringing 3 laws, 3 CRPC replacement, Indian Penal Code replacement, Evidence Act replacement, if they can make this, my question is a Lilliputian question to them. Think about it. If they can make 1,000 sections in 3 PDFs, can they not answer one question that a person is raising before the Honorable AP High Court? They can. They don't want to, because it will expose their hypocrisy.
They are being.
They will be, yes, they will in the crosshairs. They cannot answer this way or that way. They cannot say dowry giving is a crime. They cannot say dowry giving is not a crime. They are in a dilemma. They cannot file and they don't want to file. I am asking the Honorable AP High Court to strike down the right to file a counter and you decide. But now the courts are in panic. Courts thought Union of India will file a counter. Relying on the counter, I will make one decision. Unfortunately, Union of India is chickening out. They don't want to file counter. Now the entire burden of deciding my matter, the petition's prayers, is now squarely falling on the shoulders of the Honorable Division Bench. Now they are in a dilemma. What do we do? Either way, they have to pass a judgment, landmark judgment. You're getting my point. So I request my closing statement is fight false cases, illegal and vengeance and vindictive cases legally. Don't lose your heart. There are enough support systems. Make use of them, and the truth will prevail. Satyameva Jayate.
Okay, thank you, Sandeep ji, for an excellent exposition of the law of Dowry Prohibition Act and rules. And I think it was a very valuable and informative discussion, because not only you explained your WP and PAL part of it, you were also, you took the questions from my questions as well as from the audience, and you have, covered them in a lot of detail and with a lot of clarity and, clear exposition of the legal position.
Sure.
So I thank you very much, and also thanks to all the participants for joining in today on a Sunday morning. So we will put the recording.
Vivekji, one last point. Vivekji, one last point I would make. This case is the first case I have filed in my career as an advocate, and obviously speaking, the petitioners are my parents. So I am fighting for my own case and my own parents' case as my first case. So thanks all to my parents who supported me till now in all the ups and downs. And I hope they are still joined in this webinar also, looking at me right now. Thank you. Thank you.
Okay, yeah, thank you all.
Thank you,
and thanks to your parents also for giving the support to you, because every fight which a person fights for justice, if the more people support him, especially if your own family supports you, then it boosts your morale like anything. It
Yes.
gives you that confidence that your family, your parents are behind you. So I thank your parents also, that
Thank you.
they have given you,
Thank you.
their support. So okay, we will wrap this up. Thank you all for joining. So we will again have some good discussion sometime. So until then, yeah, goodbye.
Bye everyone. Take care.